The certified letter nightmare. Imagine, for a moment, a perfectly normal afternoon. You are checking your mail when you see a certified letter from the U.S. government. You open it, expecting routine paperwork, but instead, you find a notification that you failed to report a foreign bank account. The penalty listed is a staggering $30,000, your U.S. bank accounts are frozen, and if you are a green card holder, your entire immigration case is suddenly at risk. This isn't a fictional scary story. It is a scenario that will become shockingly common under a brand new banking rule taking effect in 2026. This change is specifically designed to catch accounts you might have barely used, opened decades ago, or contained only a few $1,000s. For seniors over 60, green card holders, and naturalized citizens, this represents a fundamental shift in how the government monitors your global financial footprint. Why seniors and immigrants are targeted. The government's new approach removes the old assumptions that small or inactive accounts back home simply don't matter. Historically, many people believed that if they filed their taxes honestly, they were safe from scrutiny regarding overseas assets. However, the 2026 rule changes the environment from one of forgiven confusion to one of automatic flagging and investigation. Seniors over 60 and immigrants are being singled out because statistically these groups are the most likely to have lives that span multiple countries. Whether it is a pension from a previous job abroad, a family savings account for emergencies, or a partial interest in a family home, these connections are now being viewed through a lens of strict enforcement rather than education. The Enhanced Reporting System of 2026. Starting with the 2026 calendar year, which impacts the tax returns you will file in early 2027, the U.S. government is implementing the Enhanced Foreign Account Mandatory Reporting System. This is not a minor update to an old form. It is a major expansion of how foreign financial accounts are tracked, reported, and enforced. For the first time, the rules are being applied differently based on your age and your place of birth. This system is designed to remove the "I didn't know" defense by embedding mandatory questions directly into standard forms and linking them to a massive verification network. The lowered threshold trap. The first major technical change involves the reporting thresholds. Under the old system, most people only had to report accounts if the combined value exceeded 10,000 at any point in the year. While that threshold remains for younger, U.S.-born citizens, it drops sharply for the target groups. If you're over 60 or were not born a U.S. citizen, that threshold drops to 5,000, and in some immigration-specific cases, it can drop as low as $3,000. This means an account with a few $1,000s that you never thought twice about can now trigger mandatory reporting and strict scrutiny. Even crossing this lower limit for a single day creates a legal reporting obligation. What exactly counts as a foreign account? One of the most dangerous aspects of the new rule is the expanded definition of what constitutes a foreign financial account. The government is casting a much wider net than simple checking or savings accounts. Under the 2026 system, foreign retirement accounts, including pensions and employer plans, must be counted. Life insurance policies with any cash value now count, as do prepaid debit cards issued by foreign banks and digital wallets held with foreign financial institutions. Even a partial ownership interest in a foreign property or business can trigger the rule if it generates any form of financial return. Beyond checking and savings. The system no longer cares how you personally define your assets. It only cares that the asset exists and is located abroad. Many seniors and immigrants view their overseas connections as something I've always had, rather than a formal bank account. But the 2026 rule treats a small pension in one country, a modest savings account in another, and an old life insurance policy as a cumulative total. When added together, these items often cross the new lower thresholds without the owner ever realizing it. This cumulative counting is where many honest people get caught in the reporting net. The era of real-time data sharing. The era of government agencies operating in silos is ending. For decades, people slipped through the cracks because information was not connected across different systems. Starting in 2026, the IRS, FinCEN, and U.S. Citizenship and Immigration Services, USCIS, are implementing full real-time data sharing. This means every piece of foreign financial information you report, or fail to report, is automatically cross-checked. If a foreign bank reports an account linked to you, but that account is missing from your U.S. tax return, The computer flags the inconsistency instantly, the automatic flagging machine. This new data sharing system is unforgiving because it removes human judgment from the initial detection process. The system does not ask if a mistake was minor or if the account was old. It simply generates a notice based on data mismatches. If you answer no to the foreign account question on your tax return, but FinCEN has data showing otherwise, you are flagged. For those in the middle of an immigration review, USCIS will see these unresolved financial compliance issues immediately without needing to request them from you first. Why inactive accounts are still risks. The government is also eliminating many of the exemptions that people relied on in the past. Under the 2026 system, it does not matter how often you use an account, how long ago it was opened, or who else is listed as a joint owner. If you meet the age or citizenship criteria and the connection exists above the lower threshold, it must be disclosed. The assumption that inactive or dormant accounts are gray areas is no longer valid. If it exists, it must be reported, period. The immigration connection for green card holders. For green card holders, the stakes are significantly higher because financial compliance is now directly tied to your right to stay in the United States. During the citizenship application process, USCIS reviews your tax history to establish good moral character. With real-time data sharing, they can see automatically if you answered foreign account questions correctly. Even unintentional failures to report can trigger delays, additional interviews, or document requests. In serious cases, repeated reporting failures can be used as evidence that you do not meet the standards for citizenship. The naturalized citizen misconception. A common misconception is that becoming a U.S. citizen removes these risks. Unfortunately, the new regulations specifically include naturalized citizens in the enhanced reporting group. The government reasons that people born abroad are statistically more likely to maintain long-term financial ties to other countries, even decades after naturalization. Consequently, naturalized citizens remain subject to the lower reporting thresholds and increased scrutiny, often catching them completely off guard. Work and student visa holders. These rules also extend to those in the U.S. on work visas, student visas, or other long-term temporary statuses. If you meet the substantial presence test for tax purposes, you are required to comply with all foreign account reporting rules. For those hoping to apply for a green card or citizenship in the future, a history of non-compliance can resurface years later during the application process. Financial compliance is no longer just a tax issue. It is a foundational requirement for your future in the United States. Step 1. The complete financial inventory. To protect yourself, the first step is to create a complete inventory of every foreign financial connection. This must include everything: bank accounts, even empty or forgotten ones, retirement accounts, pension funds, life insurance with cash value, and brokerage accounts. Do not forget partial ownership in foreign property or businesses, even if they don't currently generate income. For each item, record the institution name, the country, the approximate peak value, and whether it is a joint account. Gathering old statements now prevents incomplete information from triggering an audit later. Step 2. Correcting past FBAR mistakes. The second step is to review your FBAR, Foreign Bank Account Report, history. If the combined value of your accounts exceeded $10,000 in previous years and you didn't file, do not panic, but do not ignore it. The IRS and FinCEN offer streamlined filing procedures for those whose failure to report was unintentional. Taking action voluntarily before the government detects the account via data sharing puts you in a much stronger position and can drastically reduce potential penalties. Step 3. Preparing for the 2027 filing season. Because the 2026 rules drop the thresholds, you must start gathering documentation early. You may need to contact foreign institutions for official balance letters or statements showing the highest value reached during the year, a process that can take months due to language barriers or overseas logistics. You must also be prepared to convert foreign currency into U.S. dollars using official exchange rates. Keeping clear records of these calculations is just as important as the numbers themselves to avoid inconsistency flags. Step 4. Reporting worldwide income correctly. You must ensure that all foreign income is reported on your U.S. tax return. A common mistake is assuming that if income, like a pension, was taxed abroad, it doesn't need to be reported in the U.S. This is incorrect. U.S. law requires reporting worldwide income. While tax treaties may prevent double taxation, they do not remove the reporting requirement. Leaving questions about foreign income blank can now trigger automatic notices under the new system. Step 5. The power of organized record keeping. The final step in your action plan is rigorous record keeping. Save copies of every tax return, FBAR, bank statement, and currency conversion calculation. For green card holders, being able to easily produce organized documentation can turn a potentially major USCIS delay into a straightforward process. Many cases are delayed not because of wrongdoing, but because the individual cannot prove they complied with the rules. A real-world warning. Maria's story. Consider the story of Maria, a 72-year-old retiree who kept 8 Diuzozo eine savings account in the Philippines or family emergencies. She filed her U.S. taxes honestly, but never reported the foreign account because she didn't to know the rules existed. When the new reporting questions appeared, she left them blank out of confusion. The new system Nivragun detected the account automatically through data sharing, resulting in a 30-00 penalty assessment and putting her citizenship application on hold. Although she eventually resolved the issue, it cost her $10,000 in legal fees and caused a year of extreme stress. Addressing common fears and FAQs. It is important to clarify that these rules do not affect your regular U.S. bank accounts or your U.S. Social Security benefits. They apply only to foreign assets. Furthermore, even empty or dormant accounts count toward the reporting threshold if they existed during the year. Jointly held accounts must also be reported if you have signature authority over the funds, even if the money belongs to someone else. The penalties for mistakes are severe, ranging from $10,000 per year for non-willful violations to 50% of the account balance for willful ones. Conclusion. Knowledge as your best defense. The goal of the 2026 banking rule is to create transparency and consistency, not to punish honest people. By putting questions directly on standard forms and lowering thresholds, the government is removing the ambiguity that led to innocent mistakes in the past. If you start preparing now, making your inventory, gathering your records, and understanding your obligations, you can navigate this new system without fear. Knowledge is your greatest protection. Preparation provides peace of mind, while waiting creates unnecessary risk.